This is Bloomberg Law with June Grasso from Bloomberg Radio.
Time after time, President Trump has tried to freeze federal funding as a cudgel against political opponents and programs he considers woke. From freezing $10 billion for child care and aid for low-income families, to freezing $5 billion for a federal highway administration program to build infrastructure for electric vehicle charging. But also, time after time, federal courts have stepped in to lift those funding freezes. In fact, in more than half of the 167 spending fights reviewed by Bloomberg News. Joining me is the reporter who crunched the numbers, Bloomberg legal reporter Zoe Tillman. Zoe, for those who may not know, explain President Trump's use of federal funding freezes against people or groups or programs that he disagrees with.
So, from day one of the administration, and really before day one, there was this big push where Elon Musk was the face of this Department of Government Efficiency initiative. They're going to cut spending. They're going to cut the federal workforce. This was really a message from the incoming administration from the very beginning. And, right away, it was a slash and burn approach. Grants were cut, executive orders were signed right from the start saying, no more federal money is going to go to things that this administration doesn't support. So nothing that is DEI related in any way, nothing that relates to, the term they used is gender ideology, but really has to do with programs that relate or involve transgender individuals, things related to climate change, really just using the flow of federal dollars to achieve any number of policy objectives. Later on, we saw a number of actions related to immigration, including efforts to condition grants on compliance with immigration enforcement, even for grants that weren't directly related to immigration. So this has been just a big priority for this administration from day one and has been, predictably met with legal challenges from day one.
So you reviewed 167 fights over spending. Tell us a little bit more about them.
Yeah, so I should say, taking a few more steps back, we've been tracking every lawsuit against the administration, from day one to the best of our ability, with an eye to sort of looking at what the role of the courts will be and has been in, our government. Are they serving as a check? Is there an adversarial relationship with the executive branch at a moment when Congress has sort of removed itself in many ways from the policy-making sphere, and so much is coming out through executive action? What is the dynamic with courts? So with that in mind, at the 1 year mark, we decided to, drill down and look at funding to see just where the money is going or not, and what role the courts have played. So, there have been cases about really any realm of federal spending you could think of, money going to universities for medical research, scientific research, transportation infrastructure grants, agriculture, arts, media, humanities. Really every aspect of federal spending has landed in court at this point.
Tell us about some of the cases where judges lifted freezes in January alone.
There was an instance of a specific set of grants that went to a pediatrician's organization, a national group of pediatric doctors. They had $12 million in grants cut off. A number of medical groups have, found themselves in an adversarial position with this administration on everything from vaccines to care for transgender children. And the court in this instance, a DC federal judge, found that the way the government had gone about, suddenly cutting off these grants that had been approved, that was likely unlawful, and ordered them to resume paying them out. So that was an instance of sort of a direct stream of money to a particular organization. In another set of cases, there was a trio of appeals before the First Circuit involving a cut to the rate that research institutions are reimbursed for what's commonly known as indirect costs, things like overhead, facilities, not the cost of the research, but all the money spent to support that research, around it. And the First Circuit upheld lower court judge who had enjoined the way the administration had gone about doing that. And that was, costs that the government itself had estimated, were worth billions of dollars of reimbursements to research institutions. So it's really run the gamut. And, we've just continued to see orders come down that, are often preliminary, I should say. We haven't reached the final judgment phase in most cases. We're talking about temporary restraining orders. We're talking about preliminary injunctions. Some cases are nationwide. Many are not, especially after the Supreme Court last year made a big step to rein in nationwide or so-called nationwide or universal injunctions. So some of these orders have been limited to the states that have sued, the organizations that have sued, although I should say, sometimes there are membership groups that involve hundreds of individual nonprofit members or organizations. So, sometimes the relief is limited, but advocates in the course of doing this have said, if we didn't sue, we would get nothing. So they see every win as valuable at this point.
And how often did judges halt the Trump administration's funding cuts?
So as of when, I sort of cut off the data collection for this project, our data collection has continued, but for this project, as of mid-January, across the 167 cases that, we looked at the dockets, there were more orders in place halting in full or in part the contested actions in more than half, just over half. So, more often than not, there continued to be court orders either requiring money to go out the door. Some cases, it wasn't money going out the door, but it was just preserving the funding at issue or access to that funding, making sure it couldn't be redistributed amid the litigation. Other cases, there are orders lifting, I mentioned earlier, sort of conditions on grants, lifting those new conditions. So that doesn't guarantee that everyone who sued will get the money, but it means they don't have to satisfy those new and what they contend are, improperly crafted conditions to at least apply for money. So that's where things are as of end of last month.
Does the government almost always appeal these lower court orders?
Not always, often. I think that one trend that we've seen is in cases that involve very straightforward, you owe me money, you haven't paid it, and I want that money back. They are more likely to appeal, and they are more likely to seek emergency relief from an appeals court. In cases that involve conditions where there's less of a time sensitivity involved, and it's not as if a judge has literally turned the spigot back on and money has to come out. They are appealing some of those, but not always pursuing, this emergency relief. And then in some cases, they're not appealing. And, they're letting preliminary injunctions or temporary restraining orders stay on the books as the litigation plays out. It's in the first year, there was so much activity on sort of emergency dockets, not just for the Supreme Court, but up and down the judicial chain, that so many things happened on a preliminary basis. And in the moment, we, including me in our coverage, would often characterize a temporary or preliminary injunction as a win or a loss for one side or the other. But those are not final orders. And, those orders will stay on the docket, but then later on, courts might take a different position once they've had a full airing of the evidence and arguments. So I think it's worth stressing that many of these cases, even when we've had sort of quote unquote wins and losses early on, they keep going. And, there's more action potentially down the pike.
What happens to the funds? Let's say a lower court says, we're lifting this freeze, and then the government appeals. Are the funds paid out in the meantime?
They are. I mean, it depends on how the order is structured. So we've had cases where there's an injunction. I know from talking to grantees that, they've gotten the money. It might not always be a lot of money, but they've, gotten money, even with an appeal. In cases where the government gets a stay of a lower court injunction, then the government doesn't have to do anything while the case goes forward. There have been some issues with compliance, not to the extent that we've seen more recently in the immigration context, where, there have been a number of judicial rulings that have gotten a lot of, understandably, attention for saying, there's defiance by ICE when we've ordered release or we've ordered bond hearings. It hasn't reached that level in funding cases. What I've heard in reporting this story out is that, for the most part, states and nonprofits feel that the government is mostly complying when ordered to keep paying out or accept applications, what have you. But it has not always been smooth sailing, even after an injunction or temporary restraining order comes down.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Bloomberg legal reporter Zoe Tillman. We'll take a look at what the Supreme Court has done when these funding freezes have reached the justices. I'm June Grasso, and you're listening to Bloomberg. President Donald Trump's expansive efforts to use federal funding as a cudgel against political opponents and programs he considers woke remain mired in court more than a year since his return to the White House. By the start of 2026, federal judges had halted his funding cuts and limits in more than half of 167 spending fights reviewed by Bloomberg News. The rulings against the government underscore how the legal system has persisted as a roadblock, or at the very least, a speed bump, to Trump's second-term agenda. I've been talking to Bloomberg legal reporter Zoe Tillman. So some of these fights have reached the Supreme Court. Tell us about how the Supreme Court has ruled generally.
Yeah, so what the Supreme Court has said, and it's really two cases that pushed this newer jurisprudence to evolve. But what the court has said is, if you've got basically a breach of contract claim, and you're coming in and saying, this grant was approved, I was supposed to get $1 million for my project, and they terminated it, and I should get this money, or I already spent money and submitted for reimbursement, and I didn't get the money. The court has said those really belong in the U.S. Court of Federal Claims and not a U.S. District Court. The U.S. Court of Federal Claims is a specialized federal court. Its judges they don't get lifetime appointments in the same vein as U.S. district courts. It's a more limited forum. You can't get, preliminary injunctions or relief turning money back on. You have to play it out to the end. And, sources I talked to for this said, if you're a small nonprofit, you can't spend a year waiting for money. It's really make or break. You need that preliminary or temporary order from a court to preserve status quo while you litigate. So moving these types of funding cases over to federal claims, which is what the Supreme Court said needs to happen, is considered a big win for the government. And it, knocks out certain types of cases over funding cuts. But critically, these cases didn't rule out all funding fights from U.S. district courts. There are constitutional claims, even if they involve funding terminations, if it's purely you retaliated against me for exercising my First Amendment right, and the relief involves getting the money back, that is still fair game, or at least, the court didn't say you can't pursue those claims. Issues with the conditions on funding, those are still fair game to pursue. And so, advocates that are opposed to what the government is doing say that it didn't help to have these Supreme Court orders come down, but that they didn't knock out all funding fights. And judges have certainly not felt that they can't issue, more relief against the government in light of what the justices said. And I should say, the Supreme Court orders came on the emergency or so-called shadow docket. So they too were preliminary and not very fulsome. So, I quote one judge in the story who had an order that said, they felt like their funding case fell in a gray area of what the Supreme Court had said. And, barring a more fully aired judgment articulating all the ways that funding cases can be litigated or not in district courts, this judge said, I see room for me to act here.
Is there a number for how much money, how much in funding the government has frozen?
We don't have a complete number, at least not one that everyone agrees on. We know that the Department of Government Efficiency, which was, the Elon Musk driven project, even though, Elon Musk is no longer part of the administration. Doge said that they saved $215 billion, and that savings covered, terminated spending streams. It covered government employees' salaries or the cost of running agencies that were trimmed or shut down. There's also some nuance to that number where Bloomberg reported, that spending still went up in other ways over the past fiscal year, so that, might cancel out whatever those savings were. But that said, we have this number of like 215 billion. We know that state AG offices, state attorney general offices have offered their own estimates of money that they say they've protected. They'll usually say like they've protected or secured for their residents. And that can mean both, literal money going back out the door to grantees. It can mean the conditions on funding streams. It can mean, they've preserved access to a pool of money, even if it's not clear who will get it in the end. But they've offered up their own estimates, sometimes in the billions of dollars that they've, won in litigation. And it's very fluid. In one day, last month, there was an order lifting a freeze on something like $10 billion in aid funding for low-income families. So, in an instant, the numbers can fluctuate by the billions as far as what's at stake in these legal fights.
And these funding freezes are continuing. Recently, Trump tried to freeze the $16 billion Gateway Rail Tunnel between New York and New Jersey. And that's been unfolding rapidly.
That's right. I mean, speaking of fluid, that case, I think it's been a week and a half. And
feels
that
like
has
forever,
already gone through so many iterations where I think it was 16 billion that was frozen. A judge ordered it unfrozen for this massive, rail tunnel project between New Jersey and New York. The government appealed, and then the district judge sort of suspended her own order for a few days to give the government a chance to go to the appeals court to get a longer term pause on that injunction. The states then went to the district judge and said, can you lift your own pause of your own order, lifting the freeze? So it's one of those cases where, as I said earlier, when it's about money going out the door, things have moved often very quickly in a way that if we were just talking about, conditions on accessing that money long term, it likely wouldn't have unfolded at such a rapid clip.
You're anticipating, I'm anticipating too, we're all anticipating that there are going to be a lot more funding freezes connected with Trump's immigration crackdown and his railing against sanctuary cities and states.
It's a big question mark. They have not had success defending these types of funding decisions tied to, whether a city or state is a so-called sanctuary jurisdiction. There's an order still in effect from a San Francisco federal judge last year that's, being appealed at the moment. But there's already an order finding a similar effort was unlawful. So the president more recently had again said that they would pull funding from these types of jurisdictions that they feel are failing to be as cooperative as they would like on immigration enforcement. And, we, as part of this story, talked with municipal services, including the Seattle City Attorney's Office, which was part of the earlier sanctuary cities fight. And the message very broadly, not addressing specific litigation, but broadly was, if there's grounds to sue, they're ready to sue. If something is threatening their funding, money that they need for their municipal services, they're ready and able and prepared to go back to court as needed.
And I'm sure you'll be looking at that lawsuit if they do. Thanks so much, Zoe. Great research. That's Bloomberg legal reporter Zoe Tillman. Uber is facing some 3,000 cases from around the country over passengers' sexual assault claims. Last week, an Arizona jury found the ride-sharing giant liable for not preventing an alleged sexual assault of a passenger by a driver, returning an $8.5 million verdict for the passenger. The jurors found that the driver was acting as an apparent agent of Uber. However, they rejected claims that the rideshare company itself acted negligently in its safety standards or designed a deceptive product. Now, jurors came to a different result in a similar case in California state court last year. Uber says it's going to appeal the Arizona verdict. But are these bellwether cases likely to lead to a global settlement? My guest is Michael Green, a tort law professor at Washington University School of Law. Uber has been fighting sexual assault claims for a decade, and the argument is that the company can't be blamed for the misconduct of its drivers, that they're contractors rather than employees. Has that been working until now?
Just the basics here is that Uber can be liable in two respects. One is if Uber acts wrongfully, negligently on its own. Suppose Uber hires a known sexual offender to drive cars. In that case, we would say, Uber, you're negligent and you are subject to liability. The second basis, and this is what you were adverting to, is employers can be vicariously liable for the torts of their employees, okay? And that's where the Dean verdict was based. Uber says two things. One is these drivers are not our employees. They are independent contractors. And the law is that a person who hires an independent contractor is not normally vicariously liable for that independent contractor's torts. And then secondly, it says, alternatively, even if the driver is our employee, we are not vicariously liable when an employee goes off and does things that are not for our benefit. That is, goes off on a personal detour and frolic. Well, almost all of these sexual assaults, virtually all of them, are not for the benefit of Uber. They are personal, whatever they are, by the drivers. So Uber really has two claims with regard to why it's not vicariously liable.
Tell us what the jury found in the case in Arizona.
So that's the Dean case. And interestingly, what the jury found was that Uber was not negligent. So they didn't find anything that Uber did wrong vis-a-vis protecting its passengers from sexual assaults. But what they did find was that Uber was vicariously liable for its driver based on a subtle doctrine that exists in Arizona but is not widespread across the state and that would not apply, for example, in the next case that Judge Breyer is planning to try, which is in North Carolina. That is, if we had the law of North Carolina applied in the Dean case, the plaintiff would not have succeeded on vicarious liability.
The jury award of the $8.5 million was substantial, but it was far below the $24 million she'd asked for compensatory damages for her past and future sufferings. And she asked for $120 million in punitive damages, and the jury awarded no punitive damages. So what do you make of the actual amount awarded?
Well, first of all, I don't pay any attention to what plaintiffs seek. They can seek the moon. And there's no cost to them seeking the moon, right? So plaintiffs' lawyers typically will ask for lots and lots of, in the hope that somehow that will stick with the jury. Often it does not, and the Dean case is an example where that was the case. I'm not surprised that they did not award punitive damages given their finding that Uber did nothing wrong. That is, they found Uber did not act negligently. It's very difficult to get punitive damages based on vicarious liability, which was the basis for liability in Dean. You need really bad behavior, more even than acting unreasonably, to get punitive damages to convince a jury that this is really something heinous that deserves punitive damages. So I'm not surprised there were no punitive damages. Now, that's not to say that in another case, the evidence about Uber's bad behavior might not be stronger and might not influence a jury to think, wow, what Uber did here was unconscionable. And I think that would probably be much stronger for cases that occurred later rather than back in the mid-2010s, particularly the case in California.
The jury came to a different verdict in the case in California, so tell us about that.
That was a case in state court in California, not part of this federal multi-district litigation. And in that case, interestingly, the jury found that Uber was negligent for its own conduct. But they also found another element, of course, of a tort is not just that the defendant acted wrongfully, but that wrongful conduct caused the plaintiff's harm. And what the jury found in that case was that Uber's negligence was not a cause of the plaintiff's harm. That means that the jury felt that even if Uber had done better, the plaintiff in that case would still have suffered the assault that she suffered.
Is there a way to reconcile those two verdicts? I mean, is it the facts of each of the cases are different? Is it the law is different in Arizona and California? Or is it just two juries looking at the same thing and saying different things?
Well, of course, we don't know what evidence was introduced in those two cases and whether it was the same or it varied. That could very well be the case. But it could also be the case that juries simply respond to evidence differently. Earlier in my career, I was looking at a very interesting trial that was conducted by Judge Robert Parker of the Eastern District of Texas. At the time, his docket was just flooded with asbestos cases, and he was looking for a way to try and handle what was a Sisyphean task. The more he resolved, the bigger the pile got. And so what Judge Parker did was to have a trial of 5 cases, 5 asbestos cases, in the same courtroom before 5 different judges. The evidence was the same in those 5 cases. The juries, 5 juries, heard the same evidence for each of what was their case. And then they rendered verdicts. And Judge Parker gave me access to those verdict forms. And it was remarkable how on the difficult issues, the jury split and did not find consistent. I've taken that as pretty good evidence of the way in which juries can come to different outcomes. And that's part of the purpose of these bellwether trials that Judge Breyer is conducting, to see how a variety of juries will react to the evidence in these cases.
As you mentioned, and this goes to the bellwether part, there are something like 3,000 cases, obviously different facts, but also different laws in the jurisdiction. So can it still be a bellwether when you have different laws that are applied?
Well, that's part of the reason for trying cases in different jurisdictions. He's got 6 cases teed up for bellwether trials. 2 are in California, 2 are in Arizona, 2 are in North Carolina. My guess is that he wants to see how those come out before scheduling more. But you're right that different state laws, differences in the fact, some of these plaintiffs suffered horrific sexual assaults. I think that may be important to a jury in deciding these cases. So there's factual variation, legal variation across states, and jury variation that could affect and produce different outcomes.
In response to the Arizona verdict, Uber said this verdict affirms that Uber acted responsibly and has invested meaningfully in rider safety. But it is going to appeal the finding that the driver was acting as an agent of the company, saying the judge erred on the instructions given to the jury. When Uber looks at this behind closed doors, should they be motivated to start settling cases, or should they look at it and say, well, different juries can bring different results, so let's forge ahead?
The first thing I hope is that this motivates Uber to find better ways to protect their passengers. When tort law is working right, it results in better safety precautions being taken. And we can go across a whole lot of areas. Asbestos is a great example of that. So that's the first thing. I think it's probably too early. Publicly, of course, Uber is going to deny that they have any liability and appeal and do all the things that defendants who are held liable do. I think it's probably too early for Uber to say, okay, what we need to do now is figure out a global settlement. In other mass torts, as the cases develop, you see defendants seek global peace. And that's a complicated dance that occurs. And I think that's what Judge Breyer in those federal cases that you referred to is trying to develop. But first, Uber needs to get a feel, and then the plaintiff's lawyers need to get a feel on really how much is their exposure here. And these first two cases give us a little bit of information. It might be different if the first two cases both came in with very high liability and very high damage awards, or vice versa. That hasn't happened. That may suggest we're going to need to try more cases to see how juries respond.
The American Law Institute amended its restatement of torts.
Yeah, so there have been a lot of suits, not just against Uber, but by women who have been sexually assaulted in a variety of contexts. Think a woman who's arrested by a police officer. Think a woman who is incarcerated in a jail or a prison. Think about patients in the hospital. What we also found as we were doing this research is that there has been a trend, despite what I said earlier about no vicarious liability for sexual assaults because they're not for the benefit of the employer. And that was the Hornbook black letter rule. We found a number of courts finding ways to permit those plaintiffs to continue to pursue their case, vicarious liability case, against the employers of these people, employees who are committing sexual assaults. And there were enough cases where we found that the American Law Institute, which develops restatements of the law, decided last May to promulgate a special rule that says that employers of employees who are given power or control over vulnerable potential victims and who use that position to commit a sexual assault, a special rule that says vicarious liability can be imposed there by a jury. That would be a significant game changer for these cases if courts that have not adopted that rule decide to adopt it. I'm very interested to see how that provision that the ALI adopted last May plays out when plaintiffs' attorneys try to use that to convince a court in Kansas or Alaska or New Mexico to expand the scope of vicarious liability for sexual assaults.
Thanks so much for joining me on the show. That's Professor Michael Green of the Washington University School of Law. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.